Question number 51. The revenue system of Akbar's reign was in the hands of, this is also a very easy question, Todermal. Todermal was one of the 9 gems of Akbar's kingdom, and he used to have the great knowledge about the revenue system. Question number 52. Under Evidence Act, the value of medical evidence is only corroborative, is conclusive, is of no assistant, is conclusive even if contrary to credible and trustworthy evidence of eyewitness. Correct answer is only corroborative. Under the Evidence Act, the value of medical evidence is only corroborative. Question number 53. Which one of the following section of Indian Evidence Act gives effect to the principle that possession is the prima facie evidence of a complete title? Options are Section 110, Section 112, Section 113, Section 114. Correct answer is Section 110. Section 110 of Indian Evidence Act talks about the burden of proof as to ownership. When the question is whether any person is the owner of anything of which he is shown to be in possession, then the burden of proof that he is not the owner is on the person who affirms that he is not the owner. Now let us proceed to question number 54. A dying declaration can be oral, in writing, in any adequate method of communication, all of the above. Correct answer is option D, that is all of the above. Question number 55. A plea of alibi is a special exception under IPC, is a general exception under IPC, is only a rule of evidence recognized in Section 11 of Evidence Act, none of the above. Correct answer is option C, that is only a rule of evidence recognized in Section 11 of Evidence Act. Question number 56. Which section of Indian Evidence Act makes the provision that there shall be no new trial on the ground of improper admission or rejection of evidence? Options are Section 166, 165, 167, 166. Section 167 of Indian Evidence Act. Section 167 of Indian Evidence Act says that no new trial for improper admission, rejection of evidence. Now let us proceed to question number 57. Which one of the following section of Indian Evidence Act provides provisions relating to refreshing memory? Correct answer is Section 159. Section 159 talks about the refreshing memory. So, a witness may, while under examination, refresh his memory by refreshing to any writing by himself at the time of the transaction concerning which he is questioned, or so soon afterwards that the court considers it likely that the translation was at the time fresh in his memory. Now let us proceed to question number 58. Which section of Indian Evidence Act provides that no particular number of witnesses shall in any case be required for the proof of any fact? Options are Section 135, 134, 136, 132. Correct answer is Section 134. Question number 59. Under which section of Evidence Act continuous cohabitation for a number of years may raise the presumption of marriage? Options are Section 112, Section 150, Section 114, none of the above. Correct answer is Section 50. Question number 60. Who can make an admission under Indian Evidence Act? Person from whom the interest derived, an independent person witness to a proceeding the court. Here the correct answer is person from whom the interest is derived can make an admission under the Indian Evidence Act. Now question number 61. Presumption of life is contained in which of the following section of Indian Evidence Act? Presumption of life is contained in Section 107 of the Indian Evidence Act. Question number 62. For an offence under Section 376 IPC, evidence of character of the victim is not relevant under which section of Evidence Act? Correct answer is Section 53A. Section 53A, the evidence of character of the victim is not relevant. Question number 63. Which section of Evidence Act deals with the rule of res gestae? This is very important question and it has been asked in many examination. You must be aware of this answer, that is Section 6. Section 6 is related to res gestae. Question number 64. Electronic records were included in Section 3 of the Evidence Act with the effect from, correct answer is 17th October 2000. 17th October 2000. Electronic records were included in Section 3 of Evidence Act. Question number 65. Match list first and list second and select the correct answer using the codes given below. Document. Document is given under Section 3 of Indian Evidence Act. Primary evidence. Primary evidence is given under Section 62 of Indian Evidence Act. Secondary evidence. Secondary evidence is given under Section 63 of Evidence Act, and oral evidence is provided in Section 60 of Indian Evidence Act. So by going through these options, correct answer is option B, 1, 2, 3 and 4. Question number 66. A accused of theft on the occasion of and causing grievous hurt to another occasion. A must be charged separately for the theft and for causing grievous hurt. Charged jointly for theft and causing grievous hurt. Tried jointly for theft and for causing grievous hurt. Charged jointly for theft and for causing grievous hurt but tried separately for those two offences. Here the correct answer is option A, that is charged separately for theft and for causing grievous hurt. Question number 67. Warrant case means a case relating to an offence. Options are punishable with death, punishable with imprisonment for life, or punishment for a term exceeding 2 years, punishment with imprisonment not exceeding 2 years. A and B above. Here the correct answer is A and B above. Punishment with death and punishment with imprisonment for life or imprisonment for a term exceeding 2 years will be known as warrant case. Question number 68. Children of Muslim parents are not entitled to maintenance under section 125 CRPC, not entitled to maintenance under section 125 CRPC if living with divorced wife, entitled to maintenance not governed by CRPC. Correct answer is CRPC. Section 125 of CRPC gave right to children of Muslim parents also to entitled to have maintenance. Question number 69. FIR is only a report about the commission of a crime. FIR in itself is a substantial evidence. Options are 1 is true but 2 is false. Yes, this is the correct option, that FIR is only a report about the commission of crime. FIR in itself is a substantial evidence. No, FIR is not in itself a substantial evidence, but it is only a report about the commission of the offence. Therefore, the option A will be the correct option. Question number 70. R.M. Malkani versus State of Maharashtra, AIR 1973, deals with the admissibility of, correct answer is tape recorded evidence. This is very important question. It has also been asked in various examinations. You should remember the case law. R.M. Malkani versus State of Maharashtra 1973 deals with the admissibility of the tape recorded evidence. Question number 71. X is charged with for promoting enmity between two groups on the ground of language. Whose previous sanction is required before a court to take the cognizance of this offence under CRPC? Correct answer is central government or state government. Question number 72. Under which section of CRPC court has discretionary power to summon any person as a witness? Options are section 311, section 319, section 311A, section 313. Correct answer is section 311. Now let us know something about the section 311 of CRPC, which give power to the court, discretionary power to summon any person as a witness. Section 311 says that power to summon material witness or examine person present. Any court may at any stage of any inquiry, trial or other proceeding under this code, under CRPC, summon any person as a witness or examine any person in attendance, though not summoned as a witness, or recall and re-examine any person already examined. And the court shall summon and examine or recall and re-examine any such person if his evidence appear it to be the unessential for the just decision of the case. So therefore, you have to remember the section 311, which gives the discretionary power to the court to summon any person as a witness. Now let us proceed to question number 73. Facts alleged by one party and denied by other in a case is termed as facts in issue. Section 112 of the Indian Evidence Act creates a legal friction. It does not provide for presumption, provides for conclusive presumption which can be rebutted by DNA test, provides for conclusive test not rebuttable in any case. Correct answer is option C, that is provides for conclusive presumption which can be rebutted by DNA test. Question number 75. A is accused of the murder of B. At his trial, which of the following facts may be an issue? A caused B's death. A is an honest person. A has received a grave and sudden provocation from B. A was awarded for social services. Here the correct answer will be A is caused of B's death is relevant, and then A had received grave and sudden provocation of B. This is also relevant because A is accused of the murder of B. Here A is an honest person. This talks about a character which is not relevant. A was awarded for social service. This is also the character. This is also not relevant. So option 1 and 3 will be the correct answer. In the given options, B, that is 1 and 3 will be the right answer.